Welcome to another edition of Question and Answer with a Criminal Defense Attorney. I'm Mark Solomon, a defense attorney in Denver, Colorado, and today's question is about phone obstruction. But before we get going, don't forget, don't forget to click like on this video if you're liking it. Click subscribe and the little bell next to it to be notified of future videos. What is phone obstruction? Phone obstruction comes about a lot in domestic violence cases that I've done. Mostly it's when somebody rips somebody's phone out of their hands or hides their phone, somebody who is actually using a phone as a phone, not to take pictures or anything else. But it's a charge where somebody is trying to use the phone to call for help or to use the phone to talk to somebody or make a text or to send any transmission over the phone to somebody else. And the suspect or defendant in the case has interrupted that communication. So let's look at the statute. 18-9-306.5, a person commits this if they knowingly prevent, obstruct, or delay by any means the sending or transmission or conveyance of any message, communication, or report by any telegraph, telephone line, wire, cable, or other facility or cordless, wireless, electronic, mechanical, or other device. It is a Class 1 misdemeanor. Let that sink in for a minute. Class 1 misdemeanor is up to 18 months in jail. So in other words, you're having an argument with your significant other. They pull out their phone and say, "That's it, I'm calling the police on you," and you take the phone away from them. This is the charge you're probably going to be facing. So don't do that. That is the question and answer for today. If you would like to submit your own question for future videos, put it in the comments below, email me, or tag me on Twitter. And as always, you have a right to remain silent. If a police officer asks you where you've been, what you have, what you know, you always have a right to say, "I don't want to answer that question," or "I want a lawyer."